Welcome to Employment Bite. In this series, our London employment team provide bite-sized overviews of some of the key developments surrounding the employment law landscape in the UK. Whether you're an employer or employee, join us for a discussion navigating the dynamic world of employment law. I'm Anvita Sharma, and I'm joined today by Stefan Martin, and we're going to discuss the government's plans to make unfair dismissal a day one right, what we know, what we don't know, and what employers can do to prepare for the change. And in that context, it's important to remember that this change is not imminent. So what do we know about the timing, Stefan?
At the moment, as everyone will know, the Employment Rights Bill hasn't yet made it into law. It's still making its way through Parliament. And even when it gets royal assent, which will probably be around the middle of the year, unfair dismissal won't at that point become a day one right. That's largely because there are still a number of things to be worked out, as we'll find out in this episode. And the government has said that the current 2-year qualifying period for bringing an unfair dismissal claim won't change until autumn 2026 at the earliest. So for the time being, it's business as usual, and the 2-year qualifying period will remain in force until at least autumn 2026.
Can you talk us through what we know so far about the new right?
Yeah, of course. The bill worked by repealing the section of the Employment Rights Act that sets the qualifying period at 2 years. So in the future, when it comes into force, anyone who's actually started work will be able to bring an unfair dismissal claim if they're dismissed. You won't be able to bring a claim if you haven't started work. So if, for example, if an employer withdraws a job offer, unless the offer is withdrawn for an automatically unfair reason. So, for example, if an employer withdrew a job offer because it found out that its prospective employee was pregnant, the individual would be able to bring an unfair dismissal claim as well as a discrimination claim.
Okay, so assuming an employee has started work and is then dismissed, they can bring an unfair dismissal claim.
That's right. So on day one, if an employer dismisses an employee, that would give them a right to claim unfair dismissal. And that's led to a lot of concern from employers that it will be a brake on their desire to hire new staff, because I think it feels quite risky to take someone on if on day one they have a right to claim, even if you feel they're totally unsuited to the job, that they'll have to go through a time-consuming process before being able to dismiss the employee fairly. So to try and address some of those concerns, the bill introduces what's going to be called an initial period of employment, which provides that if the individual is dismissed during that period, the normal rules on unfair dismissal won't apply. Now that's reassuring, but we're still waiting a lot of the detail on exactly how the initial period of employment will work. So, for example, at the moment, we don't even know how long this initial period of employment will be.
That's correct. The government has said it's minded to set the initial period of employment at 9 months, but that is going to be subject to consultation. One amendment to the bill specifies that the initial period of employment has to be somewhere between 3 and 9 months, but because this is not a government amendment, it's unlikely to proceed.
Yes, I mean, I was initially puzzled at the suggestion that it would be 9 months, and there's been a lot of commentary asking why the government's suggesting a 9-month period when a normal probationary period would generally be around 6 months. Now, doesn't that make a 9-month period excessive?
I'm actually a bit more sympathetic to the government on this one. It's not that uncommon, as you know, Stefan, for an employee to get to the end of their probationary period and for the employer not to be sure whether they're suitable. And that might be a particular issue if the employee has had a period of absence during the 6-month probation period. So I think having a 9-month period is really designed to stop an employer feeling that they're forced to dismiss instead of giving the employee a bit longer to see if they can do the job. So I would see it as a measure to encourage employers to give employees a bit longer to prove themselves and not take an early decision to avoid having to follow a full-blown unfair dismissal process.
Yeah, I get that, but how do we know how the procedure during the initial period, whether that's 6 or 9 months, will differ from an ordinary unfair dismissal process?
That's a bit of a known unknown at the moment. All the bill says is that there will be regulations modifying the way in which the normal fairness test operates for dismissals during the initial period of employment. So that will include a situation where an employer terminates on notice during the initial period of employment, even if the actual termination date falls outside that period, provided the employee's notice period is 3 months or less. There's still no further detail about what this truncated process might be, other than a slightly concerning suggestion that the regulations might provide that a dismissal will only be fair if an employer has taken specified steps. And that's a bit reminiscent of the statutory disciplinary and grievance procedures that used to be in place, isn't it?
Yes, it is. So for those with long enough memories or who are old enough, like me, the statutory dismissal procedures applied for around 5 years until they're abolished in 2009. And they made unfair dismissals automatically unfair if an employer had failed to follow a statutory process when it dismissed an employee. Now, that sounds quite onerous, but the requirements themselves were actually relatively light. All that an employer had to do was to set out the basis for action in writing, hold a meeting with the employee to discuss, and then allow an employee a right of appeal against the disciplinary decision. But in practice, actually, they led to a lot more disputes, increased costs, and created a lot of satellite litigation about whether the employer had actually complied with the statutory process. Now, so far, the government has said that during the initial period of employment, there should be a meeting with the employee to discuss the employer's concerns. The employee would be allowed to be accompanied by a colleague or a trade union representative, but we don't know any more than that. And the government is going to be consulting on exactly what a fair process might entail. Now, I think that's likely to happen later this year, so employers should be watching out for that and preparing to engage with the consultation process as and when it occurs.
The other thing it's worth pointing out is that although commentators have been calling the initial period of employment a statutory probationary period, that's a bit misleading because it really does go further than that. The light touch procedure will not just apply to capability or performance dismissals, but it's also going to apply to conduct and illegality dismissals and to dismissals for some other substantial reason relating to the employee. But crucially, it will not apply to redundancy dismissals.
But does that mean that employers will have to follow a normal fair redundancy process for all employees, regardless of their length of service?
Yes, in a redundancy situation, all employees will have to be pooled in the normal way, selection criteria applied, and consultation carried out, regardless of length of service. It might be quite challenging to apply selection criteria to employees with very short service, and that's something employers will have to think about quite carefully when the reforms come into force. In one other development, there's a possibility that compensation for unfair dismissal during the initial period of employment may be lower than the existing statutory cap. So, Stefan, can you tell us a bit more about that?
Yes, that possibility was initially flagged in the Next Steps document the government published alongside the Employment Rights Bill. Now, the government has formalised that by introducing an amendment to the bill, allowing it to apply a different compensatory award limit to dismissal during the initial period of employment. So that would mean that even if a dismissal during the initial period of employment is unfair, the employee would receive a much lower or potentially much lower level of compensation. Now, depending on where that level is set, it might make it attractive for employers to have a protected conversation if someone's not working out during their initial period of employment. So, for example, the employer could suggest a settlement agreement knowing that any compensation would be capped at 3 or 6 months' pay, for example. We don't actually yet know what the level would be in practice. In that sense, it looks a little bit like the no-fault dismissal proposals that proved quite controversial under the former Cameron government, which would have allowed employers to dismiss fairly by paying the employee a set sum. Before deciding to have a protected conversation, an employer would need to think about whether there were any discrimination or other claims in the mix where compensation limits don't apply, and that lower level of unfair dismissal compensation wouldn't therefore be relevant. Now, before we close, I think there have been some less welcome amendments or developments for employers in the government amendments.
This time relating to time limits for bringing tribunal claims. So another amendment will increase the time limits for most tribunal claims, including unfair dismissal, from 3 to 6 months. That's clearly going to raise the prospect of employers having to defend more claims on their merits in the future and not being able to rely on time points to get them dismissed at an early stage. That brings us to the end of today's Employment Bite. Thank you for joining us. We'll be back with another bite in a couple of weeks. And next time we'll be talking about the fire and rehire proposals in the Employment Rights Bill and the impact this will have on employers.